We are told the laws exist to protect victims. But if that were true, survivors wouldn't have to fight so hard just to be believed. The truth is that the law is structured to appear protective while remaining narrowly defined, outdated, and deeply inadequate. What's written into law is not the full reality of abuse. It is a portion that's easiest for institutions to manage. The legal system relies on rigid definitions. If harm does not fit those definitions, it is treated as if it does not exist. This is not a flaw, it is a design choice. Abuse is complex, ongoing, and often non-physical. The law, however, prefers isolated incidents, clear timelines, and visible evidence. Anything outside that, psychological abuse, coercive control, financial restrictions, legal manipulation, etc., is routinely dismissed or minimized. Post-separation legal abuse is a clear example of systemic failure. Abusers use the court system to maintain control after a relationship ends through repeated filings, custody manipulation, procedural delays, and financial exhaustion. Yet legal recognition of this abuse is often limited to married couples in active divorce proceedings. That means the law acknowledges the tactic, but only for a specific category of victims. Unmarried partners, long-term relationships, and many co-parents are excluded despite experiencing the same pattern of harm. Control does not require marriage. Abuse does not end with separation. The law's narrow scope leaves survivors exposed by design. Domestic violence laws heavily prioritize physical injury, bruises, fractures, hospital records. But decades of research confirm that non-physical abuse is often more pervasive, more damaging, and more predictive of lethal violence. Coercive control, threats, isolation, intimidation, and economic abuse are not secondary harms. They are core mechanisms of abuse. When the legal system requires visible injury, it forces survivors to endure escalating violence before intervention becomes possible. This is not protection. It is institutional negligence. Because the law is reactive rather than preventative, survivors are told to wait, document, and endure. They are asked why they didn't leave sooner, why they don't have enough evidence, or why the abuse isn't severe enough. Meanwhile, abusers exploit legal loopholes with impunity, knowing the system moves slowly and definitions remain narrow. The result is predictable. Victims are re-traumatized, abusers are empowered, and harm continues under the cover of legality. The law does not fail victims by accident. It fails them because it has not evolved with reality. If lawmakers truly intend to protect victims, then legal definitions must expand to reflect how abuse actually operates. Post-separation legal abuse must be recognized regardless of marital status. Domestic violence laws must fully include coercive control and non-physical abuse. Protection must be preventative, not contingent on visible injury or legal technicalities. Survivors do not need symbolic protection. They need enforceable, modern, reality-based law. Until that happens, the legal system will continue to do one thing very well: call itself justice while leaving victims unprotected.